to listen to a discussion of what is by definition not a very interesting subject, because the subject here is settlements, whatever that means. We'll talk about that, but not settlements of the kind that are discussed 99.9% of the time. That is to say, those involving Israel, but those involving situations in the rest of the world. And I say that it's an inherently not interesting subject because there is so little discussion. But hopefully I'll demonstrate to you the importance of this subject. So we know the question of settlements and occupied territory is much discussed in the context of the Israeli-Arab issue. That's the one thing I'm not discussing. I'm not discussing. And I'm discussing settlements in general in a global empirical approach to better understand the legal regime that applies to this much discussed question. And as you can see, we have a picture of illegal settlement construction here, and you can think about throughout the lecture whose it is. So this is something being built right now in the occupied territories, but I won't tell you whose yet.
I give a guess.
Okay. So first of all, what do we mean briefly when we say settlements? Settlements is not a legal term. There is no international treaty or instrument that uses the word settlements. Rather, settlements is a shorthand, and we can have some ideas why that word is used. But settlements is a shorthand for a particular prohibition in the Fourth Geneva Convention. So all of the legal discussion on settlements is based on one sentence in one treaty, and that is Article 49, Paragraph 6 of the Fourth Geneva Convention, which discusses the treatment of civilians in wartime, and inter alia, amongst other things, the rules that pertain to a belligerent occupation. So in the situation of a belligerent occupation, the Geneva Convention has several provisions about population movement in Article 49.
Is there a non-belligerent occupation?
There could be, but it would not be in the Geneva Conventions. There are other UN mandates. The United Nations peacekeepers may be in Bosnia. Maybe there are other kinds of non-belligerent occupations. So Article 49 is principally interested in the question of what we would today maybe call ethnic cleansing, expelling the population of an occupied territory from the territory. And Article 1 is about the occupied power kicking out the people from the occupied territory. And Article 2 through 5 are further elaborations of that and particular rules about that. Article 49.6 is on a different subject, slightly. It's about moving people in to the occupied territory. And it says, in a situation of occupation, the occupying power shall not deport or transfer its civilian population into the occupied territory. So the question is, what does this mean? Deport or transfer? What's the occupying power have to do? Does voluntary civilian migration count as deportation or transfer? There's lots of questions that arise about this. Almost invariably, these questions come up in the context of the Israeli-Palestinian conflict. And I'll give you an example of what I mean. There's a very fine document prepared by the International Committee on the Red Cross called the Guide to State Practice under the Geneva Convention. Now, in international law, this is a very important thing to know, in international law, state practice is a primary means for understanding what the law is. Especially if you have a term in a treaty which is not clear, you look at what states do, because there aren't courts that hear cases on a regular basis in international law. What determines international law to a large extent is minhag, the practice of states, the actual behavior of states. Those are, instead of cases, instead of judicial decisions, the primary data points for inferring and determining what international law actually is. So the International Committee for the Red Cross makes a wonderful document, it's in 3 volumes, where they take each and every single provision of the Geneva Conventions, and they have a detailed list of everything every country, every international forum, every UN commission has ever done or said based about that provision, about its legal application. And indeed, there is a very long section on Article 49.6. It's about 20 pages, I believe. This thing. And it is entirely, without exception, about the conduct of Israel and what various countries and UN commissions, what they think about that conduct, which is, to make a long story short, that it's illegal. Now, this is supposed to be a comprehensive guide to state practice, and this would be very interesting if there were not other situations of colorable or arguable settlement activity, by the same definitions, elsewhere in the world. It turns out that this authoritative reference guide is seriously incomplete. It turns out that the movement of civilian populations into an occupied territory is a rather common, almost ubiquitous phenomenon in situations of prolonged occupation. And what we're going to discuss today is a large and extensive research project of mine, unhappily too large, in which I seek to study what has not been studied, namely, where has this conduct occurred elsewhere in the world, and what has been the international reaction, and what has happened, and how has it been understood. And this is, I seem to be the first person to have done this, but it's rather normal international law methodology. You plot all the dots of what's happened, and then you find a line that connects them. It's pretty simple, pretty straightforward. The reason I say it's a large project is because for each one of these situations, let alone all of them, there is very little publicly available information. As I like to say, with no irony, where is Shalom Akshav when you need them? That is to say, establishing the basic facts, like how many settlers there are to within a few 100,000, in many of these situations, is far from simple, because frankly, nobody has counted them, or people count them in different ways. There is no clear answer, and we do not have the benefit of having dedicated, devoted human rights organizations who count every single house, let alone count to the nearest 100,000. So that makes it somewhat hard to figure out the basics. Okay. The basic point is that the phenomenon of movement into an occupied territory is an international problem, or an international phenomenon. One finds it around the world. This picture is cute simply because you see settlement construction going on right now in a particular occupied territory, and next door, this is just to illustrate the international phenomenon, you have the flags of all these countries flying. Those aren't actually countries that are occupying the territory. That's just because they want to attract people from various countries to the occupied territory and do business with people from and as you see, you have Carrington, Homes Abroad, and no secret, it's in northern Cyprus, and they are marketing this primarily to British, but to a wide variety of other Europeans. So that's the international face of settlement. Why am I doing this? Why am I doing this? Because there are a lot of questions, and if we look at this phenomenon, we can maybe answer a bunch of questions. Actually, the third point is the reason I started this project. I started this project to answer a very narrow question, and the evidence and data I've collected, it turns out, is useful for many other questions, far more interesting than I expected. My narrow initial inquiry was, assume you have a situation of illegal deportation or transfer into an occupied territory, as we'll see occurs in various places around the world. What is the remedy? What is the legal remedy? As you may know, in at least one context, it is widely suggested that the legal remedy is the expulsion of the transferred or deported population from the occupied territory, their removal from that territory. So my original question was, why do we think that's the remedy? Is that the remedy? What does state practice show is the remedy for violations of this of this legal norm, but it can actually teach us about a lot of other things. It turns out it can teach us about the basic definition of what does the international community regard as a settlement, as deportation or transfer into international territory. It can teach us about a more political science kind of question. What's the international reaction to this kind of conduct? And to more particular legal questions which have been lately discussed in certain contexts. Are there any restrictions on economic activity with settlements or in areas of settlements? And just to be cute for this context, what if you have a university in occupied territory? Does that have any special significance? As you may know, many people think it's a particular problem to have a university in a territory that is thought to be occupied. So even very, very particular in the Kudot like that, we can find answers to, because of the great wealth of data and precedent that we can collect from around the world.
I'm not talking about Tel Aviv University.
No. Okay. We're just going to keep this up. This is basically what I'm working on. This is basically the situations I'm looking at. As you'll see, there are three situations I mentioned at the bottom. Those are not formally part of my study, and I include them by way of illustration, just to try to be strict and limit my data set to comparable cases. I try to only look at occupations that began after 1949. Because one might say, well, maybe before the Geneva Convention, maybe before a country signed the Geneva Conventions, these rules were not applicable. So while there are interesting things going on with the Russia and the Baltics and China and Tibet, and certainly France and the Saar, they're not necessarily strictly part of the study. Though, of course, France occupied the Saar for many years after it signed the Geneva Conventions, and actually annexed the Saar, which some would say isn't what you're allowed to do with occupied territory, but at least France, which was one of the original parties, one of the original drafters of the Geneva Convention, did not see any incompatibility between those conventions and creating a protectorate in the Saar, whose primary purpose was the extraction of the coal from the Saar and shipping it into France. This was the original Jean Monnet plan. That is to say, the original idea of the European Union was France takes the nice pieces of Germany, and that's a European Union. Eventually it was decided to give away those pieces of Germany to West Germany, not because anyone ever suggested there was an international legal problem with it. No one ever did. But rather because it was thought to be, it would be helpful in strengthening West Germany against the Warsaw Pact, and this would be a helpful way to do that. Again, even though I conducted a fair amount of research, it's very hard to tell whether any serious number of French nationals moved into the Saar. The answer seems to be no, but not for any reason of an international legal compunction.
Didn't France consider the Saar part of France?
Yeah, so like a protectorate. Yes.
Pakistan and India.
We'll get there. But we're actually not going to get there because that was before 49. It does not seem there was a significant movement of Frenchmen into the Saar for a very simple reason. The situation of France after World War II was, as you can imagine, a massive labor shortage. Wages in France skyrocketed after World War II, and indeed, people from Germany tended to be attracted to France for the wages. So it was impossible to attract people to the Saar where they didn't really pay any money because it was a protectorate. And indeed, it seems the only situations in which we do not find significant migration into the occupied territory is when there's an extreme economic gradient to overcome. That is to say, not because people think it's illegal, but simply because it doesn't make sense. And the only other example that one can find like that, just to get it out of the way quickly, is the Jordanian occupation of Palestine from 1949 to 1967, when there was massive migration from Arab communities in Palestine to Jordan because of the much higher standard of living in Jordan, basically no one would want to come to the Arab towns of Palestine, which were much, much poorer. Everyone moved to Amman. Okay, those are unusual cases. So let's deal with some primary cases. And I'll just tell you the stories. And we can then see what happened in them. And what's great about all of these situations, as it happens, is the ones that we're going to focus on, all post-date 1967. So if you look at things before 1967, one might say, but maybe then we decided to have a better rule, or we decided that was the wrong approach. This is all under the approach, the supposedly current approach. So in 1975, as Portugal was withdrawing from East Timor, there was an idea of the United Nations that there should be a referendum there and self-determination. Instead, Indonesia invaded, drove out whoever was left of the Portuguese. There was a brief fight, and Indonesia occupied East Timor, otherwise known as Timor-Leste, as it is now known. Indonesia occupied the territory from 1975 until 2000. During that time, a very considerable number of settlers moved into the territory, about 170,000. This number is actually fairly well counted, which the number to the right is the percentage of the population of the territory that it represents. That is, if one is measuring the magnitude of a settlement activity, there's two ways to do it. You can either just look at the number of people, which might tell you something, but that doesn't really help in places like Armenia where nobody lives anyway, and 10 people is a lot. So also the percentage of the population of the occupied territory. Indonesia had a very active and aggressive program, an explicit program to move people to these places. It was called a Javanization program. Indonesia is actually an empire, a large island archipelago dominated by the Javanese people, and they wanted to move more Javanese people into East Timor, and they did this through a very, very active program. Most of the people they moved were peasants, were farmers. So they first gathered up the peasants by offering them some money. They put them in these special camps where they trained them in how to farm in East Timor, which it's all Indonesia to us, but apparently you need to do something different in East Timor. And then they put them on ships, sailed them over, and built a bunch of towns for them. While the United Nations did condemn Indonesia's original takeover of East Timor, it never said a word, nor did any country that I have found issue any objection to this very public Javanization program. Indeed, as far as I can find, the only international reaction I have been able to find, and I'm very happy for someone to find another one, is that they got a non-trivial grant from the World Bank to finance the Javanization program, the importation of these migrants, because it was an economic development. It was helping promote the economy of East Timor. So the international community never at any point, not in any United Nations resolution, nor in any Foreign Office statement that I have found, expressed the view that this conduct was illegitimate or illegal.
With the people living there, did they make any complaints?
They made a guerrilla war that finally resulted in Indonesia leaving. They made a very big complaint. They had
What's the population? What's the ethnic?
Timorese. I mean, there were always some Javanese there, but they were a very great minority. Are they Muslims?
The Catholics, no.
I don't know. They're Catholics. Yeah? Okay.
Catholics.
They also have linguistic differences. So they. What?
What happened to the 20%?
Oh, that's the question, isn't it? That was my original question. What happened? So the fate of the settlers did become an issue when, after this long war and a change in the government in Indonesia and the end of the Cold War and many other contributing political factors, Indonesia decided to leave East Timor, which would become an independent country. And there were internationally sponsored, UN-approved peace negotiations about how that exactly should happen. The fate of the settlers was a question in these peace negotiations. And in what's going to become a very common pattern in the cases I will illustrate, the only question was this: how many of them get to become citizens immediately? Or even an anterior question. First, Indonesia was going to leave and was going to first have a referendum in East Timor. Do you, the people in East Timor, do you wish to be part of Indonesia or not? So the only two questions about the settlers were, do they get to vote in the referendum about whether to end the Indonesian occupation? That is to say, this was not an Indonesian referendum. It was a referendum just in Timor-Leste. Do they get to vote? And then if the answer is yes, if it's going to become an independent country, what percentage of them become citizens automatically? And what percentage have to be granted permanent residence status? The movement of a single settler was never discussed. But the only question was, do they get to be citizens automatically with all the benefits, or will they be Indonesians with mandatory permanent residence afforded by the new country of Timor-Leste? So the answer was, indeed, they do get to vote in the referendum, and they did have a referendum which voted for independence, and there was some split. Half became citizens, half became permanent residents. The international community which sponsored these negotiations never suggested the expulsion of a single settler. Okay, so that's Indonesia, East Timor. But maybe one might think that was then, this is now. This indeed ended 14 years ago. So the next couple cases we're going to discuss. Actually, let me do another one before we'll do Morocco and Northern Cyprus in a bit. They're actually ongoing occupations, which are in many ways extra interesting and extra relevant. I want to touch briefly on two other cases in historical order: Vietnam and Cambodia. This is in numerical terms perhaps the largest settlement enterprise we see here. And it's one that almost nobody even knows ever happened. But it's also interesting for another reason, which I think will become self-evident. So there was always an Annamese. The Annamese are the ethnic Vietnamese people, the ethnic majority in Vietnam. There was always an Annamese minority in Cambodia, and a Khmer majority. They have not gotten along for several hundred centuries. Naturally, the French used the Annamese minority as their colonial assistants, and that probably didn't help matters. And there's been a long history of tensions and intercommunal violence. During the 70s, when pretty much every bad thing that could happen happened in Cambodia, one of the bad things happened was massive anti-Vietnamese pogroms, which forced out hundreds of thousands of the Vietnamese minority, and they ran away to Vietnam. Vietnam subsequently invaded Cambodia in 1978 and occupied it for well over a decade. During that time, maybe 500,000, in the span of only 10 years, Annamese civilians moved into the occupied territory. For a variety of reasons. It's very hard to understand what was happening. There might have been some government encouragement. Other people came for other reasons. But there was a great deal of them in a very short space of time.
They were originally inhabitants of that area.
Not all 500,000 of them.
Okay.
Maybe 150,000 fled in these pogroms, and then a lot more came. But yes, there was always an Annamese minority there. The fate of the Vietnamese settlers was also discussed in the internationally backed Paris Peace Accords, 1988-1999, which to discuss the framework for a Vietnamese withdrawal. Again, internationally sponsored, principally French-sponsored peace conference. And even though it's probably the most obscure example here, the Vietnamese settlers in Vietnam, they hold in Cambodia, hold a special place in my heart for two reasons. First of all, it's the only time that one finds that in the context of a discussion of a withdrawal, the question of the removal and expulsion of the settlers is raised, and for another reason. Okay, so in the Paris Peace, and it was a very small thing, but there are a couple of protocols from the Paris Peace Conferences that do show that the Cambodian representatives, it was not really a big or particularly central part of the discussions, but they did say, we don't just want the Vietnamese army out. That's not enough. We would not consider that an end of the occupation. We want all the ethnic Vietnamese out. To which the French mediator said...
Did they make a distinction between the original Vietnamese?
We'll get there. We'll get there. No, the Cambodians did not make that distinction. To which the French said, excuse me, you want what? They said, we want all the Vietnamese ethnic people to go away. And the French said, well, how can you say that? That sounds very racist. They said, well, we see them, we've never liked them, we didn't get along, and after the occupation, it will only perpetuate tensions and there will never be peace, and we will see them as civilian colonizers, and we just can't get along. And the French said, that's really not the kind of thing that you can politely ask for in polite society. Let me tell you how to rephrase that question. The way to rephrase that question is, maybe some of them will get automatic citizenship and will be full-fledged Cambodian citizens, and some will get permanent resident status, and indeed that's what the negotiations proceeded to be about. A minority, I think 20-30%, got full citizenship, and the rest were allowed to stay as, the rest of the 500,000 were allowed to stay as permanent residents. By the way, this is also one of the only situations where there was any international reaction. There were several General Assembly resolutions, a whole bunch, maybe one a year for a period of 8 or 10 years, condemning Vietnam's change in the demographic character of Cambodia. So this was something the General Assembly knew about, and they said, we don't think it's a good thing, the Vietnamese coming. At the same time, the General Assembly, nor did any country, ever suggest that this change in the demographic character of Cambodia was illegal under international law, let alone a violation of Article 49.6 of the Geneva Convention, that provision which the General Assembly, as you may recall, in the years 1978 to 1999, talked about a lot in other contexts, so it's not that they just forgot it existed. They never found it to be applicable to this situation, even though they thought it was bad as a political matter. Okay, the second reason this has a very special place in my heart is having done a very comprehensive, I hope it's comprehensive, I think it's comprehensive, search of the international legal scholarship on the question of Article 49.6. The only discussion I have found by any law professor of Article 49.6 in any other context is a footnote in an article by a very distinguished American international law professor, Stephen Ratner at Michigan, about the 1999 peace accords. And he says that the Cambodians were saying that it was a violation of Article 49.6 and they want them out. And he said it doesn't really seem that it would be a pure 49.6 violation, because given that some of these people had only been expelled from this area 10 years before, that doesn't seem to be obvious. We don't know. The same people, which people, no one really knows anything about these people. Again, there was no Charles Marchov counting the Vietnamese settlers, but he said, this is not what 49.6 is about. That's not what it's about, that's not how we're going to understand it. So that's the only other mention I have found. There is that, so it's a special place in my heart. If I had found no mentions, I would think I was running my search fundamentally wrong. But this actually provides some verification for the methodology. Okay, so again, those settlers who want to, maybe half of them, maybe 2/3, they stay in Cambodia.
And they're still there now, actually, the descendants.
I mean, most of them. The Cambodians weren't completely wrong. Indeed, the existence of the Vietnamese did lead to friction